friends, I am Dr. Purnima Khanna, Assistant Professor from Khalsa College of Law, Amritsar. Today we will discuss a very important topic, that is the history of law reporting in India. In the present module, we will learn about the history of official reports. Secondly, the history of non-official law reports. Thirdly, we will discuss about the significance of law reporting and also about the main objectives of the law reporting. My dear learners, let's begin with the brief overview of the topic. The law pronounced by the apex court of the country is followed by the courts subordinate to it by the theory of stare decisis, the theory of precedent and ratio decidendi. In India, the Supreme Court of India is the apex court and its judicial precedents are authoritarian in relation to all the high courts and subordinate courts in India. And the record of a judicial decision on a point of law which sets a precedent is called a law report. There are more than 300 law reports published in India today. The law of India was not codified as it is today before the advent of British rule. There were principles that existed in society and concepts such as that of dharma that governed over the people. The British rule, however, brought with it British laws, and as the English developed laws in their own land, they were passed down to the Indian subcontinent. The East India Company systematically introduced the English laws, including principles such as stare decisis and obiter dicta, into the Indian judicial system. According to theory of precedent and the theory of stare decisis, the law pronounced by the superior court of the country is followed by its subordinate courts. A judicial precedent of the Supreme Court of India is authoritative in relation to all the high courts and subordinate courts in India. Now, the reporting of the precedents of the superior court is called law reporting. It is pertinent to note that in Bengal Immunity Company Limited versus State of Bihar, All India Reporters case of 1955, the Supreme Court held that it can depart from a previous decision if it is convinced of its error and its baneful effect on the general interest of the public. The same is the position in the high courts also. Dear learners, let's discuss about the main purpose of law reporting. The major reason for the easy availability of these precedent cases is law reporting. Law reporting makes precedent case laws easily available to judges, legal practitioners, researchers, academicians and law students. The purpose of a law report is to distribute the judgment of courts to judges and lawyers to widen the base of legal knowledge and to prevent two different theories on the same issue. The statutes cannot explain all matters in all walks of life. Still, there shall be some lacuna. Such lacunas are filled up by the judges of the superior courts in some extraordinary cases. Law reporting in pre-British era India. As discussed earlier, as part and parcel of the British judicial system, the theories of precedent, stare decisis, ratio decidendi, obiter dicta, etc. have been developed in Britain. Step by step, the British judicial system was introduced in India by the East India Company and later by the Crown. Now, here an important point is Supreme Court at Calcutta. In the year 1774, the Supreme Court was established in Calcutta. It marked the beginning of the system of law reporting in India. In the beginning, the system of law reporting was highly unorganized and unreliable. The government didn't take any steps in law reporting. The decisions on the cases of the Supreme Court were covered by private reporters, and even they were left unassisted and unsupervised. Despite these unorganized reports of some private reporters, there were certain authentic reports as well. Thus, reports were no doubt published, some of them good, some of them of an inferior quality, and there were periods for which no reports existed at all, and during which many valuable decisions passed altogether unreported. In the year 1824, the Consideration upon Hindu Law by Sir Francis Macnaghten and Dissertations of Mohammedan Law by Sir William Macnaghten contained important decisions on personal laws. Small's collection of orders from 1774 to 1833, published in 1834, contained notes of cases. Many other reports, like that of Longvilla Clark's Rules and Orders, Morton's reports, Bignell's reports, Fulton's reports, Taylor's reports, etc., were published, and they made a rich contribution in the development of law reporting in India. Now, like the Supreme Court of Calcutta, an attempt was made to start law reporting in the Supreme Court of Bombay. The cases decided by the Supreme Court of Bombay were published by Parry's Oriental Cases. Sir Thomas Strange published in 3 volumes the cases of the Supreme Court of Madras, covering the period from 1798 to 1816. In the similar way, the cases of Supreme Court at Bombay were also compiled and reported by some private persons. Then Sadar Diwani Adalats were there. The first law commission suggested the proper codification and law reporting of the cases decided previously by Sadar Diwani Adalats. Sir William Hay Macnaghten, Registrar of the Adalat, compiled 7 volumes of cases from 1791 to 1849 pertaining to the Sadar Diwani Adalat at Calcutta. Some more efforts were made to publish the subsequent cases. Act 12th of 1843 had a suggestion to the company that the judgments in English of Sadar Adalats should be appropriately recorded and be published monthly. However, this suggestion was not successfully implemented. Borodale collected some cases pertaining to the Sadar Diwani Adalat at Bombay in 2 volumes in 1825. There were 5 volumes of criminal cases belonging to the Nizamat Adalat at Calcutta, compiled by Sir William Macnaghten. Then there were Sadar Nizamat Adalats also. A law report containing only sentences of the Sadar Nizamat Adalat at Calcutta was published in 5 volumes. Monthly reports were published from 1851 onwards of cases from Sadar Nizamat Adalat of Calcutta. The reports containing criminal cases decided by the Sadar Faujdari Adalat at Bombay from 1827 to 1846 were published. Publication of monthly reports from the Sadar Faujdari Adalat at Madras was started in the 1850s. What about the law reporting in high courts? The Indian High Courts Act 1861 made the provisions for the establishment of the high courts in various provinces. The judgments of the High Court got recognition in quantity and quality. The Madras High Court published the cases in 8 volumes covering from 1862 to 1875. The private publication started law reporting with Weekly Reporter, Indian Jurist at Calcutta, Hayes Reports, Marshall Reports, Corrigan's Reports, Burke's Reports, etc. at Calcutta, and Madras Jurist at Madras. They contained very valuable judgments of the high courts. The Indian Law Reports Act 1875 is very important legal point here. The Indian Law Reports Act 1875 was brought into existence with the idea of curbing the ever-growing number of private law reports. Several private law reporters had begun accumulating cases and case notes and were selling them in bulk. The issue here was that the idea behind law reporting is reporting new precedents and not simply putting together a huge number of cases. Moreover, only a few of the reports were genuine and contained compilations of important cases. Some of the cases reported were good and genuine, but the majority of the cases reported contained nothing new law points but repetition. To charge high, the private publication accumulated every case and began to sell in bound volumes at the rate of rupees 250 per 1 year. Like this, they began to exploit the legal practitioners. Some of the law reporters were not giving case facts and simply giving judgments. They didn't mention what the actual new points were delivered by the judgments and how they would act as precedents in future. Their motto was profit only. Sir James Fitzjames Stephen, law member of the Government of India, and Sir Hob-House, law member, were unhappy with the trend of law reporting. They wrote to the government and explained the situation. As a result, the Indian Law Reports Act 1875 was enacted. The Act of 1875 could not suppress non-official reports. The main reasons were delay in official reporting, incompleteness, costliness, rigid bureaucracy, etc. Due to these reasons, non-official reports continued to be in existence and were giving high competition to the official reports. The non-official reports began to get fame in the bar and the bench. This act was intended to control the indiscriminate citation of the cases in the courts. Section 3 of this act runs as follows: no court shall be bound to hear, cited, or shall receive or treat as authority binding on it the report of any case decided by any of the said high courts on or after the said day, other than a report published under the authority of the Governor General in Council. This act was objected to prevent the indiscriminate citation of unofficial reports. Its purpose was to diminish the quantity of law reporting and to improve its quality. However, this act was severely criticized by the bar and intellectual persons. Further, this act was applicable only to the high courts. It didn't mention about the decisions of the Privy Council, Federal Court and the Supreme Courts. The Law Commission in its 14th report described the Act of 1875 as a dead letter and wrote, "The Indian Law Reports Act was repealed because of many reasons, such as the delays in the publication of the Indian Law Reports series. The provision of Section 3 were not observed by the courts. Indeed, the judgment of all courts, including those of the Judicial Committee of the Privy Council and the Supreme Court, have referred to decisions published in private series as authoritative and binding. However, as a result of the Indian Law Reports Act 1875, all the high courts in India began to publish their official reports from 1876 onwards. High courts of Bombay, Calcutta, Madras, Allahabad, Patna, Nagpur, Punjab, Delhi, etc. published yearly law reports regularly. My dear viewers, let us learn about various forms and types of law reports. Firstly, full text law reports. These reports incorporate the entire judgment that has been given by the court along with a head note, which includes the summary of the judgment. These reports are often cited in preference to summary reports. Next are summary reports. Summary reports are those law reports which only include the summary of the case as seen in the case digest. These are also comparatively less formal as compared to the full text reports. Then there are official reports. Official reports are those which are published by the authorities. They are not very popular even today, since they are updated slowly and often quite expensive they are. One such official law report in India is Indian Law Reports. Some of these are worthwhile to mention, viz. The Madras Law Journal, the Allahabad Law Journal, the All India Reporter, Madras Law Journal, etc. There are some regional laws reporting institutions also started, such as Andhra Law Times, Kerala Law Times, Nagpur Law Times, Patna Law Times and Madras Week Notes. The official reports are inadequate and are having shortcomings. They are very expensive and very slow. Bureaucracy kills the official reports. They are not reported regularly and punctually. They are the most costly. Therefore, the advocates tend to purchase unofficial reports and rely upon them. The Law Commission observed, if the publication of this series, All India Reporter, under government auspices is based on the duty of the government to make the law appearing in the decisions of the courts available as soon after the decision as possible to the courts, the professionals and the members of the public. The gross delays in the publication of the series indicates a grievous neglect of the duty. But for the existence of non-official law reports, the judges and the lawyers practicing in the court would have been for months without any guidance as to the law laid down by the courts. The Indian Law Report series, as now run and published, may well cease to exist without any detriment to anybody, except perhaps to those employed in its publication. Then moving ahead, there are non-official reports. These are privately published law reports. These days, non-official reports are often favored over official reports due to the speedy publication. However, since they are privately published, they may charge a high fee for providing their services. Moreover, non-official reports tend to be repetitive. That is, they may undermine the purpose of a law report, which is to provide information on new precedents. Some of these worthwhile to mention are the Madras Law Journal, the Allahabad Law Journal, the All India Reporter, etc., which we have discussed earlier also. Then there are All India Reports. These reports, official or non-official, accumulate and publish precedents from across states. Such reports will contain precedents set in the Supreme Court, High Court of Madras or High Court of Maharashtra and so on. All India Reporter is an example of a non-official report in India. Indian law reports would be an example of an official law report. Then there are state specific reports. These reports are confined to a particular state. They publish precedents set only in the assigned state, such as the Allahabad Weekly Reporter, a non-official report, or ILR Patna, an official one. Then there are special law reports, which are published keeping in mind a particular legal field or aspect. These law reports accumulate information regarding one particular issue or field, such as labor law or company law, and publish new precedents established in these fields alone. Examples of this would be income tax reports or labor law journal, etc. Privy Council. The important judgments of the Privy Council were reported in 77 volumes from 1872 to 1950. Then Federal Court. It was started in 1935 and continued till 1949. The Federal Court report published all important judgments given by the Federal Court. Now, my dear learners, let us see what is the status of law reporting after independence. After independence, law reporting became an organized sector in India. The number of institutions involved in law reporting increased in number. Now, the law reports published by various institutions are highly precise and reliable. Today, there are various law reporting journals for every High Court and also for the Supreme Court of India. High Courts. The High Court of a state is the highest court of the state and all other courts of the state work under it. The judgments of all the high courts are published by various law reporting journals. Some important law reporting journals are All India Reporter, Andhra Legal Decisions, Gujarat Law Reporter, Kerala Law Journal, the Calcutta Law Journal, Delhi Law Times, etc. Supreme Court of India. In place of the Federal Court and Privy Council, the Supreme Court of India was established at Delhi in 1950. There are several reporters reporting the Supreme Court judgments, such as All India Reporter, the Madras Law Journal, Supreme Court Journal, Supreme Court Weekly Reports, Supreme Court Cases, etc. Law Commission and Law Reporting. What are the observations of the Law Commission? The question of law reporting in India is dealt with by the Law Commission of India, which was established in 1955. The Law Commission also gives certain valuable suggestions for improvement of law reporting. The Law Commission has omitted to consider the desirability of undertaking the reprinting of old law reports. It is submitted that in the interest of administration of justice, it is necessary that the project shall be undertaken either by the government or some private agency under the supervision of the government. Dear learners, let us discuss about the merits of law reporting. Law reporting is very useful to the bar and bench. Every advocate seeks its help and prepares his case according to the precedent case laws. For the courts also, it is easier to decide the case on similar facts and points of law. Thus, law reporting is very useful in courts for the easy and early disposal of the cases. There are certain demerits of law reporting also. The private law reporting institutions generally have commercial nature and aspects. This commercial nature kills the originality of the nature of the judgments. Between the private law reporters, there is a highly unhealthy competition. To increase the size of volumes, the private publications give a large number of cases, which are in fact unnecessary. The cases decided on similar facts and on the similar points of law have been repeated. This consumes too much time and huge money of the advocate and judges. There is high possibility of poor quality in the private reporting. Some of the law reporters contain the interlocutory matters with no final adjudication. Repetitiveness and overlapping, etc. are very common. Let's see what is the effect of technological advancement on law reporting. Several legal databases have popped up, such as Manupatra, LexisNexis and a few others, which act as search engines relating to anything and everything in the legal world. In these, a person has access to case notes, entire judgments and legal dictionaries, all at the click of a button. These databases, being on the internet, can be accessed at any time and the information available on them is never ending. Reports published by private organizations are also accessible through these databases and they are quite helpful. The only drawbacks here would be that access to these databases is not free and they are quite exhaustive. In other words, they can be quite confusing to navigate unless one is experienced with using these databases. Dear learners, it may be concluded that law reporting in India is not a new concept. However, due to the sheer number of reports created, it may seem that the overall quality of reporting may go down since there is a lot of repetition. However, today the coexistence of official and non-official reports has come to be seen as a healthy competition instead of a limitation. The quality of reporting has also risen. Law reporting definitely has come a long way and can be expected to improve more as the years pass by. In spite of its demerits, law reporting in India is progressing day by day. It serves advocates, researchers, students as well as eminent judges. I hope this lecture helps you enrich your knowledge. Thank you very much.